YNW Melly's attorney Stuart Aldestein has filed a motion to set bond with Judge John Murphy on Tuesday afternoon. I believe this is the third time that Melly's team has filed a motion to set bond. The first time being back in 2019, where Melly's first lawyer said that Melly has never purposely missed a court day and is not a flight risk. The second time being in 2020, where he tested positive for COVID and tried to get out, but he was denied again for being dangerous. So here's the motion right here. State of Florida versus Jamel Demons. Motion to set bond. Comes now defendant Jamel Demons by and through his undersigned counsel files this motion to set bond, and grounds therefore states the following: that the defendant Jamel Demons is charged in superseding indictment with 2 counts of first-degree murder with a firearm that occurred about the 26th day of October 2018. On February 8th, 2019, the Miramar Police Department issued an arrest warrant authorizing the arrest of the defendant. 5 days later, he voluntarily surrendered to the authorities at Broward County Jail and remained in custody since that time. I remember when that happened too. People were freaking the fuck out back in 2019. They were like, oh, he turned himself in, so he's guilty. Like, people just have a misunderstanding, dude. Don't understand that they don't want to be on the run like TK. It's a terrible look to, you know, a jury and a judge that you were on the run. So you don't want to be on the run, obviously. The defendant commenced trial in this cause on April 11th, 2023, and the court declared a mistrial on July 22nd, 2023 because the jury could not reach a unanimous verdict. The defendant has remained in custody for over 4 years and has never requested a bond hearing, Arthur hearing, until now. Oh, so this is a different type of hearing. What's an Arthur hearing? If your attorney successfully gets you an Arthur hearing, there will not be a jury. During it, your attorney and the prosecution will present their case to a judge. Because there's no jury, the judge is the only person your attorney has to convince. In phase 1, the prosecution will present evidence in form of documents or witnesses establishing proof of evidence. The crime is committed. This is a high burden. In the second phase of the hearing, the court determines whether bond is appropriate by considering factors such as flight risk, any previous criminal history, whether you pose a danger to the community. Basically what we already know, that the judge has to decide if Melly's a flight risk or a danger to the community, or potentially, you know, fucking with witnesses or something, which I don't think, just put him on house arrest, you know, make it so he can't fucking leave the house. I mean, that'll solve a lot of things, but I know a lot of people think Melly shouldn't get out, so I get that. I don't fucking know anymore. The co-defendant has been charged with the same charges and an additional 2 counts of accessory after the fact. He's out on bond. Obviously, the difference is they're saying Melly pulled the trigger, so that's why he's been staying behind bars, I believe. Although the defendant is charged with non-bondable offenses, the court has had the discretion to grant bail even in capital cases. So then he states State versus Harper, which is a case from fucking 1980. Since the criteria for denial of bond is that the proof of guilt is evident, the presumption great that the defendant committed the crimes charged, the defendant submits that he must be granted reasonable bail. In fact, the proof evident presumption great standard is stronger than proof beyond reasonable doubt to deny the defendant bond. Verse Thursby, which is from 1966. And then in another case from 1998, the court ruled before a trial could deny bail, the state must carry the burden of establishing that the proof of guilt was evident, that the defendant committed the aforementioned crimes. So that was basically Melly's lawyer pointing out other cases with serious crimes like this where they got out on bail. In this case, the state has obviously failed to prove beyond reasonable doubt that the defendant committed the crimes of first-degree murder when this court declared a mistrial on July 22nd, 2023, because the jury could not reach a unanimous verdict. Since the standard of proof to deny defendant bond is the highest standard of proof, the state failed to do so. The defendant is entitled to bond. We all knew that his team was going to pull this card. I see a higher chance now because there was a mistrial and, you know, a judge could be like, all right, I get it a little bit, but I doubt it. I just don't see the judge leaning that way, but it wouldn't surprise me. Defendant Jamel Demons respectfully praised this honorable court to grant this motion and set a reasonable bond. My boy Bryson Paul, shout out this guy. He tweets a lot of good shit about the trial and other trials. Let's see what people are saying below the tweet. Let's be honest, they can't give bond for a double murder trial. This already 4 bonds rejected between 2019 and 2021. I thought it was only 2 or 3. The bond machine says Melly's team has never requested a bond hearing. Apparently they've never requested an Arthur hearing. Might as well try. I don't think he'll get bond either though. We know this, but I guess it don't hurt to try. It's a new trial. If granted, which I doubt it will be, bail will be in the millions and he'll be on house arrest. The smart thing to do would be to wait it out until the next trial. He should save the money for attorney fees and other expenses. Melly being out of bail is good for him recording a bunch of music before the next trial. You know he's working behind bars. It would suck if he never got to hear the new songs. Probably odd considering I'm so invested in this trial, but I've never heard a full Melly song. Yeah, Melly's team and Melly's family obviously want him out just for his mental health and to be around him for as long as possible, but you know they're also thinking in the back of their head like, shit, he could get out and record a whole goddamn album real quick. He'd probably be recording like 10 hours a day just to bang out as much music as possible, because I'm pretty sure they have ran out of verses from him and they don't have much music left. Ain't getting bond on a double murder death penalty case. Good luck. Yeah, I'd say it's about a 10% chance, maybe 20% chance he gets it, but this is a death penalty case. I just don't see the judge doing that, bro. I really don't. Boy had laughing gas.
Hey, I feel like I'm already on that shit. don't want no more. I don't want no more. I don't want no more now.
Alright, I'll turn it down a little. Just want to take it out.
I'm high. I feel like a fluffy ass llama. I feel fluffy, like, what the fuck?
Bro said, I feel fluffy. Another thing I should quickly update you guys on is they're not going to be able to redepose Detective Moretti, the lead detective on the case. The finish failed to show good cause for redeposing Detective Moretti. Rule whatever does not require the state to inform the defendant that a witness will not testify as to specific subjects as long as the state has appropriately designated all witnesses. So they were trying to redepose him because he was talking about the cell phone towers and shit, which they apparently didn't talk about in their deposition. So that's why they were trying to do that, but that got denied. Yeah, that's it for this quick update. There's a status hearing on Friday, so I'll cover that as well. If you're new to my channel, subscribe from my Twitter, Instagram. Fucking love you guys. Peace out.